Moving on, the real money gaming industry is staring at a tax liability of over 1 lakh crore rupees. The Directorate General of GST Intelligence is reportedly sending tax demands to several companies. Showcause notices have been sent to Dream 11 and the company has moved Bombay High Court. The company has alleged that the notices are arbitrary and added that it calls for taxing the entire contest entry amount. Amidst this backdrop, the GST Council will meet in the 7th of October. And to elaborate on these new developments, joining me now is Abhishek Rastogi, founding partner of Rastogi Chambers, and Saurabh Agarwal, partner at EY. Abhishek and Saurabh, welcome to Startup Street. Let me quickly start with you, Abhishek. What do you make of these show-cause notices? The real money gaming industry is staring at a tax liability of over 1 lakh crore rupees.
I think to be very fair to the online gaming industry, these show-cause notices are arbitrary. And when I say that with full responsibility. One, the valuation with respect to the specific rules for online gaming cannot have a retrospective effect. The rule which is there currently is only for betting and gambling and not specifically for online gaming. If there is an amendment today with respect to online gaming, you cannot say that these online gamings are all in the form of betting and gambling, and hence the valuation must be on the bet value. That is completely arbitrary and discriminatory. So I think that will come into play. The another element with respect to valuation is for the element of that actionable claim. When the money is with respect to participant, it would not fall within that actionable claim purview. So from that perspective, the valuation could be only to the extent of the platform fee of these online gaming companies.
Okay. Sort of quickly coming to you now, GST demand notices seek about 18,000 crore rupees from Dream 11. Games 24/7 has a pre-show cause notice of over 20,000 crore rupees. The company hasn't received a formal show cause notice yet, but we learned from sources that at least 5 more notices are there on the way. Gaming companies said this kind of money doesn't exist. The industry does not have this money. Your thoughts on this?
So, 2-3 points which I want to highlight over here. First, when you see even after the amendment in the law, when you look at the amended law, which will be effective from October 1, what government is wanting to tax is only the amount which is getting deposited into the wallet, not the bet amount. Vis-a-vis, if you look at all these demands which have come for the past period, they are wanting to tax the entire bet amount.
Yes.
So, multiple times if you are betting from the same wallet money, if you go back and see these show cause notices, they are wanting to tax all these particular bet amounts, which is not even aligned to the law, which they are coming up with effect from October 1. So that's point number 1. Point number 2, when we look at the amount of these particular show cause notices, for a gaming industry to survive, it's a question of survival. With such demands, no one has made such GGRs. If no one has made such GGRs, how will they pay back this particular money? That's the second point. Third point is, even if when they are contesting these demands, there's significant amount of pre-deposits which will be required to be made. And everyone is now looking forward to the Supreme Court judgment around it as to what will the Supreme Court say. Because if the Supreme Court says that the show cause notice is valid, the biggest issue which will come across is how will many of these gaming companies make the pre-deposit to file the first appeal and then subsequently the second appeal.
Yes, also because, coming to you, Abhishek, if you look at the earnings of these companies, online gaming revenue in 2022 was 13,500 crores and real money gaming revenue was 10,395 crores. So help us understand on what basis are the tax notices being served?
These tax notices will also have to cross the barrier of Article 19(1)(g), which is my right to carry on business or profession. And at some point of time in courts, both Article 14 for discrimination and arbitrariness and vagueness and Article 19(1)(g) will have to come into play, because the tax demand would be arbitrary if it is more than the revenue of the company. So arbitrariness creeps in. Secondly, if this demand is sustained by law for some reason, Article 19(1)(g) will also come into play, because both of these on an aggregate base will completely defeat the purpose, etc., and will have to be tested.
Okay. So, Abhishek, also take us through what are the technicalities in the show cause notices. Dream 11's writ challenges DDGI's show cause notices in Bombay High Court. It says notices lack jurisdiction and deserve to be quashed and set aside. So what should and what can gaming companies do now?
I think one and foremost important point is that we should not restrict the arguments only to the show cause notice. We must go to the pre-SCN consulting as well. While I understand that the law has been changed and the word shall is may, there is a discretion with respect to these pre-show cause notice consulting, but Supreme Courts all across have held that when there is a discretion in law, that must be used very cautiously. So in a lot of these cases, the petitioners have not gone into the step prior to the issuance of show cause notice, which is at the DRC 01 stage. And if that test is done, most of these initial at the inception stage will fail because the proper process and procedure has not been followed. While these may be discretionary powers, it could be at the discretion, these have not been followed. And Supreme Court and separate cases have also held when the root is not correct, then the tree will also not be correct. So I think they will have to go a couple of steps back to see how these proceedings started. Well, what are the lapses there? When these pre-show cause notice consultings have happened, in one of these cases, they've just said that you pay this amount, where pre-show cause notice consulting cannot lead you to a payment, which is against the principles of natural justice. So I think few of these companies will be able to still sail through if they are highlighting on these issues.
All right. Saurabh, your words on this. Also, the 52nd GST Council will discuss issues with respect to setting up of GST appellate tribunals. The council will meet on 7th October, but will this really work and how will this help gaming companies?
So if you look at, there are two ways of dealing with this issue. One is, as my friend Abhishek talked about, which is the litigation route. The other way is more around the advocacy route. The way the amount of pre-deposits, etc. are, I think, and the way the law has been worded in the past vis-a-vis the way they have come out with the law, it clearly showcased that now the law has been worded in a manner in which they want to levy tax, and that is to the extent only on the deposit value, not even on the betting value. Therefore, what the industry is expecting is a leniency from the government, and they do expect that during this particular council meeting, there should be some clarity, some circular which should come across. At least, even if the demands are coming and even if the litigation is happening, that may be limited to what the change law is saying, which is on the deposits made into the wallet and not on every bet. That's first part. Second part, which I wish to highlight is, even if you look at globally, one of the best practices which are being followed in the gaming industry is to levy tax only on the GGR value. Vis-a-vis in India, where we are going ahead to levy it on the deposit into the wallet. Even if you see the way they have come up with the revised law, they are taxing it by virtue of a rule. They are saying that they are making a change into the rule and saying that they will levy a tax on the amount which are getting deposited into the wallet. Assuming I have not betted anything and I want to withdraw that money, then also I am required to pay the tax, which is against the principles of GST law itself. Therefore, what our view would be, or what we would suggest, is that to go for advocacy, expect some leniency during the 52nd GST Council is what we look.
All right. Unfortunately, we've completely run out of time, but many thanks, Abhishek and Saurabh, for joining us on Startup Street. And like you said, the word is the show cause notices are arbitrary, and we'll have to watch, 7th of October is the next meet. We'll wait and watch for that one. Thank you so much for joining us today.
Thank you.
On that note, it is time for us to head into a short break. But coming up next, online visa application startup Atlas gets $12 million from Peak 15 and Elevation Capital. How will the firm use the funds to scale its business? We find out from the founder on the other side. Stay tuned.